the manufacturing working group here for SAPVIA, and we are doing a follow-up webinar from our previous webinar focusing on NRS and NRCS. So delighted to have you with us. Just to mention as well that we are recording the session, and so for those who perhaps not able to join us, we will make that available as well. It was a hugely successful first session that we had, closing the compliance gap. And today we're going to be looking at perhaps practical insights on the NRS and NRCS. Two very special speakers joining us today. We've got Wilele Mkhize. He is the head of Department for Licensing and Compliance at NRCS, and Ruan Kutsia, who is an attorney with nearly a decade of litigation experience, having represented various clients. He's, of course, representing Bravo Scan for us this morning. So a warm welcome to you. I'm going to be handing over to our first speaker shortly. But just to mention, the SAPVIA Manufacturing Working Group, our group of manufacturers representing across the country, and we meet quarterly to discuss some of the key matters in the manufacturing sector. Just come off an interesting session this morning with those in the manufacturing space and looking at some of the challenges facing. And we are desperately trying to ensure that manufacturing is healthy and supported in South Africa. So I do encourage you to connect with our SAPVIA working group, and can please get in touch with our team as well. Right, so I'm going to start with our first speaker, which is our gentleman from NRCS. This is Wilele Mkhize, serves as the head of Department for Licensing and Compliance at NRCS, and is a seasoned energy specialist with significant expertise in the electricity sector. He's got a Bachelor of Science degree from the University of Cape Town and a Master's degree in Electrical Engineering, also from UCT. He began his professional journey at Eskom. He worked for 2 years before advancing to roles across multiple divisions within Eskom, including generation, enterprises, at the head office, megawatt, and the distribution as well. And in 2021, Wilele joined the National Energy Regulator of South Africa, or NRCS as we know it. He earned his MBA in Business Administration back in 2023, and he's currently pursuing a PhD at Wits Business School. A focus on reforms in electricity distribution. His research is dedicated to analyzing and enhancing policies and strategies for reform within the electricity distribution industry. Wilele, delighted to have you with us. Thank you so much for your time. And I'm going to hand over to you.
Thank you. Thank you very much, Chairperson. Good morning to yourself and to the colleagues that have joined us on this webinar. I am delighted to be part of this this webinar. We have been invited to share some of our experiences in as far as compliance is concerned in the PV industry, and without probably taking too much of time, I will just state, Chair, that NRCS is very much engaged when it comes to issues of compliance. We often have to do audits around the country. I'm sure some of the people that are in this webinar, they are owners of PV facilities, and they've seen us, coming into their facilities to do audits. And of course, what's important when it comes to compliance is issues of understanding the standards to which one has to be compliant with. And so my understanding is that this webinar, its purpose is to highlight some of the, the standards as well as the guidelines that are applicable when it comes to not only installations, but also in terms of manufacturing of PV, the PV equipment, as well as in terms of their installation. But I think what is key is to understand the difference between the NRS standards as well as the NRCS standards, which is the national regulator for compulsory specifications. And so I think if we delve into trying to understand the difference between these two, then we would have accomplished the purpose of this webinar. So, Chair, I'm not sure how much I need to delve with at this point in time, but in what I have prepared here, I would want us to go through the applicable NRS standards, which are applicable to PV installers as well as those who purchase equipment that is related to PV, as well as applicable IEC standards, ISO standards, and then lastly to look at the NRCS standards, which help PV installers as well as those who import equipment into the country. So, Chair, I'm not sure. I think this is probably an introduction. I should then probably get direction from you in terms of whether we should delve into this or in terms of the program that you have, how you have planned your program.
Thank you. Well, Lelia, thank you so much for your time. Really appreciate it. And just to mention as well, I've pulled up here a look at our last webinar that we held, and speaking about the clarification on NRS 097 and compliance standards. And I just wanted to put this up here just to encourage those of you who are on the webinar today to make sure, if you haven't got a copy of this, please do contact our team. This was a lot of hard work put into this about the misapplication of 097, the NRS standard that was presented to us in our last section here. And thank you to Bravo Scan, who were with us last time, ensuring regulatory clarity in the renewable energy sector. A very good article here. So this is available if you did not perhaps receive that in our last session. I want to introduce our second speaker then. He is part of our session here today, and that is someone who's been very instrumental here, Ruan Kutsia, an attorney with nearly a decade of litigation experience, having represented clients in the Magistrates Courts, High Courts, and Supreme Court of Appeal. He currently serves as the compliance officer for Bravo Scan, and they're an approved electrical inspection authority where he oversees legal compliance, inspection processes, and business operations across multiple departments. He's got a strong foundation in law, compliance, and business management. He's developed expertise in navigating regulatory frameworks, building risk models, and ensuring accountability in a high-stakes environment. He combines his legal acumen with strategic leadership to strengthen both operational excellence and client trust. He's also currently pursuing his qualification as a SANAS compliance officer and a single-phase tester while growing Bravo Scan. His long-term vision is to blend legal expertise with marketing and compliance, positioning himself as both a trusted legal professional and a forward-thinking business leader in the electrical industry. Really grateful to have them part of our discussions in the first webinar. And Leon, wonderful to have you with us. Look forward to hearing from you as well here this morning. Ruan, are you with us there this morning? Okay, so apologies there. We'll have to come back to you. Mr. William Sinatemba, you are joining us. Please assist us here.
Yes, I think Mr. Kotsia is just having some issues with joining, but yes, he'll actually be with us shortly.
All right, thank you. So I mentioned while we're busy doing that, I mentioned an article that we had prepared from our previous session. And I wonder if I could quickly just share that with you. This was from our previous discussion. This is the one that I was referring to earlier. It was an article that was published from our first webinar on SAPIA clarifying NRS 097 and compliance standards and understanding the scope of NRS 097 versus SANS. That was the key discussion. We defined NRS, we defined the SANS standard, and then talked about particularly inverter compliance and the misinterpretation from various municipalities around the country. We're very grateful for Bravo Scan, who prepared all of this for us, and looking at then NRCS. And just as a conclusion, and please, this script is available, this presentation and the webinar. But there was a very clear focus here that encouraging municipalities and regulatory bodies to apply these compliance requirements and standards correctly of NRS 097, the SANS 10142-1, and the NRCS. And so this webinar today then really is just a key follow-up from that discussion that we had previously. So just creating a bit of context there. So unfortunately, Ruan, we're just waiting for him still to join us. So I wonder if I could ask William Mkhize just to continue, if you would mind, just in terms of what you'd prepared to share with us, and then we'll hopefully have Ruan joining us shortly just to assist a little bit further. William, are you able to jump in for us there?
Yes, good morning once again. Yeah, I think maybe to make this engagement worthwhile for our listeners, I think we need to be able to just touch briefly on what the requirements are, when it comes to either installing or the maintenance of PV systems, because of course, as the regulator, we regulate all PV installations that are above 100 kilowatts. Any PV system that is above 100 kilowatts must be registered with the NRCS, and of course, it is then subjected to being exposed to some form of regulation, which includes ensuring compliance. But of course, I need to correct myself there also, because it's actually not all installations above 100 kilowatts that we regulate. We only regulate those that really supply the public, such as those that are part of the REAP program and other licensed entities. But I think, being that as it may, I think what's important in this particular webinar is for those who are in the industry, who are in the PV industry, just to understand what are the applicable standards, and as well as ensuring that when installations are being done, that they comply to the applicable standards. And of course, as you've mentioned, Chair, one of the applicable standards is the NRS 097, which governs issues of grid connection. In fact, it covers all embedded generators. And this, of course, ensures that there's safe integration with the grid. And so installers must then ensure that their installations, including inverters, are indeed compliant with the standard, because of course at municipal level, for example, as you correctly said, this is some of the standards that they should ensure that the equipment is tested to meet this particular standard, so that the inverters that are connected to the grid do not interfere with the quality of the supply in their respective grids. And then, of course, Chair, I don't know how you want us to proceed, but there's also the SANS 10142 standards, which also provides guidelines in terms of safe wiring and the installation in premises. And this is, of course, another important safety standard, occupational safety standard, that the installation must be compliant with, to ensure that the system works in a manner that is that is acceptable when the tests are conducted. It needs to be able to meet those standards. And of course, there is also a need to employ a registered person to be able to sign off both the design as well as the installation. So Chair, these are some of the things, and I think, but what I think is important, based on what you've said in the introduction, is ensuring that the inverters that are purchased, that are used, they meet the NRS 097-2-1 standard, and of course that they should include anti-islanding functionality, so as to ensure that they are able to engage with the grid in a safe manner. So Chair, maybe I should leave it at that for now. And I think probably to make the session more engaging, I think we would probably want to allow for questions and for persons to also share their experiences with regards to the NRS 097 standard or any other, compliance-related matters. Thank you, Chair. Over to you.
Yeah, thank you, Willile. I appreciate that. Sinatemba, you want to make a comment?
Thank you, Chair, and thanks to Mr. Mkhize. I think it is just for the interest of this session, if maybe for Mr. Mkhize to share with us his presentation on his side, just for the benefit of our audience as well. Thank you, and over to you, Chair.
Okay. All right. I like the idea of doing a couple of questions there. We have one already posted here, so we could ask Mr. Mkhize there. And then perhaps when you're answering this question, Mr. Mkhize, you can just, if you are able to share a presentation or some of the comments, we welcome that. Sinatemba, if you could also just confirm for us about our second speaker, what's happening there. But yeah, we've got a question here, Mr. Mkhize. The City of Cape Town are not allowing off-grid connections for home users. We've seen that that's actually illegal based on our previous discussions. What to next? Do we report them to NERSA? What is the way forward? We've spent time on these sessions clearly defining what is required of SSEG, NRS 097, the NRCS. If there are municipalities that are perhaps making their own rules, which is what we discussed in our previous webinar, where do we go then as consumers? What is the next step? I don't know if you could speak into that, Mr. Mkhize.
No, thank you, Chair. I think the question is quite a bit of an oxymoron. I'm reading it, Chair, saying COCT are not allowing off-grid connections. So so you are not connecting to the grid. So why would they not allow? Because what they own is the grid. So if you are not connecting to their grid, then I just don't understand how they could be able to sort of encroach into your own property in terms of what you do. So I must say that is illegal. I agree with you. You should be able to, if you are off the grid, you should be able to do your own thing. But again, just the importance of making sure that the installation is still compliant, to ensure that your installation is safe to use. I think that's still applicable, So the short answer is you don't need, as long as you are fully disconnected from the grid. And I know it's quite a tricky thing, because being off grid means that you are not utilizing any power from the municipality or from the city. That means that the cables that are at the meter are completely disconnected. So I think it's also important, Chair, to be able to define exactly what it means to be off-grid, because it does mean that there is no supply at all to the house. So in that way, then you can then be able to install whatever alternative supply that you want. So I think from the perspective of the city, I think they are probably of the opinion that you are still utilizing their supply, and so therefore you are probably not completely off grid. So, but it would be interesting to hear a bit more from Mr. Burley, just in terms of the details there.
Sure.
Thank you, Chair.
Thank you, Mr. Mkhize. Please, if anyone has any other further questions, I think we have a rare opportunity here now while we perhaps wait for our second speaker or for any further presentation to be able to engage with NERSA. So if anyone has any questions or comments, we're more than welcome that. Mr. Mkhize, I think one of the key things that's happening is that municipalities sort of are adopting, where are they getting their direction from? Is it SALGA that's giving them the direction in terms of the embedded generation, the descriptions? Because we're seeing different municipalities adopting different things. Where's the directive coming from? Perhaps you can speak into that. And just again, encouraging anyone else who have any comments or questions just to post them onto the chat. Thank you.
Yeah, look, as licensees of the energy regulator, municipalities should be getting direction from the regulator. But of course, as you said, there is other organizations like SALGA, as well as AMEU, that sort of exist to assist municipalities and to ensure that there's a collaborated effort in whatever that municipalities endeavor to do. And so they should be then getting direction either from SALGA or from NERSA. But what is sometimes unfortunate is the fact that some municipalities, they just tend to do their own thing. And so I think if there is any sort of irregularity or any thing that a customer or an installer is uncomfortable with, they should be able to approach the regulator, because the licensee, as a licensee, that municipality has got to account to the regulator at the end of the day. So if there's anything that the installer or the customer is uncomfortable with, they can always come to the regulator to bring that concern, and then we can then engage with the municipality concerned.
Yeah. Okay, another question. It's not posted there, but one of our participants has sent me a question here on my cell phone, which I'll read here. Just can you clarify NERSA's role in enforcing compliance with NRS standards, perhaps versus the NRCS regulations? Where's the responsibility of NERSA in terms of NRS standards, and what's the responsibility of the NRCS? I'm not sure. There's maybe some confusion there. Can you comment on that?
Yeah, Chair, based on just the prepared presentation that I've done, what is significant is the fact that NRS standards are the standards that all licensees and all sort of installers or installations need to be in compliance with. So when it comes to the NRCS standards, these in general, they guide the probably the installers mainly of the PV installers. Maybe let me just read this to you. It says, for South African solar PV installers, the most critical standards are the SANS 10142 for overall electrical installation safety, as well as the NRS 097, as we have mentioned, which is for utility connection. So if you're going to connect to the grid, you must make sure you are compliant with the NRS 097. If you are off grid, like the earlier question, it's important also that you comply at least with the SANS 10142 so that you can get a COC and that your installation is fit for for being issued with a certificate of compliance. So I think and then it goes on here. Let me just see. The NRCS compulsory specifications issues compulsory specifications for electrical products, and it's the installer's responsibility to ensure that components of the solar PV system meets these requirements. So the NRCS is mainly for ensuring that the products that are purchased, either imported or locally purchased, are compliant. So it sets a sort of like a standard for ensuring that what is purchased is in compliance with our grid, as well as other issues like I mentioned earlier, the ability to island and so on. So I think that is the main distinctions. And maybe the other part of the question was, what is our role in terms of enforcing compliance? Well, I think for the longest time, the ERA, which is the Electricity Regulations Act, was very clear in terms of what is the role of the energy regulator. So if you read section 18, it talks about the fact that if there's any non-compliance to license conditions, so each licensee that we license, the license is issued with license conditions that must be adhered to for the duration of the license. And with IPPs, we've also issued licenses with license conditions. And therefore, when we do audits, when we visit those facilities and we, come and do the audits, we are just there to primarily make sure that they are still compliant with the license conditions. And part of also what they need to be compliant with is the grid code. So I think it's very important that if you are going to be in the PV business at utility scale, that you are familiar with the grid code, you are familiar with the NRS 097 standard, as well as the other standards that we've mentioned. For example, there's ISO standards also that must be adhered to, the 9001, the 14001, which is the quality standards, the environmental standards. And so I think, the other important one is also the IEC 6125, as well as the IEC 61730, which are critical international standards for PV module testing. So I think what's important is that the installation must be done in accordance with these standards, so that later on, when we do those compliance audits, then the installation does then is then compliant with those standards. Because of course, when we do the compliance audits, we make sure that the installation is first of all in compliance with the grid code, as well as with the applicable standards.
Okay, thank you. Mr. Mkhize, are you able to share your screen and share this presentation that you keep referring to? Are you able to share it with us?
I would like to, but I mean, it's just scribbles.
Okay.
Gareth,
Okay.
it's just the scribbles I've made for myself. Yeah.
Okay.
But
That's
I mean,
fine.
of course, I can share something more formal, just for the participants after this webinar. I don't have a problem with that.
Yeah, so that's fine. We're going to continue then with a bit of Q&A with you, because we are getting confirmation that unfortunately our second guest is unable to join us. So Ruan Kutsia from Bravo Scan, which is a pity, but we understand we are all under pressure. So Ruan, yeah, certainly missed, and we will try and engage and get another opportunity. Wendy, you have a comment?
Yes, apologies, Gareth. Ruan managed to join. We just had a few technical issues there, but he managed to join. He is on the call currently.
Oh, okay, yeah. Wonderful.
Apologies for that.
Okay.
Thank you.
Okay, thank you, Mr. Mkhize. We do have more questions for Mr. Mkhize, but Ruan, I think if you don't mind, we'd like to jump in straight away and have you share what you've prepared for us. I think it's going to give some context. We've been discussing and answering some questions for Mr. Mkhize from NERSA. So Ruan, can you jump on board there and continue with your presentation that you prepared for us?
All right. Sorry. Yes, thank you. I do apologize for that. My invitation said this was going to be at 1. And the aspects of the documents that, or well, the presentation that we presented was last time in terms of the NRS, if you can remember.
Correct.
Just want to, sorry about that.
No problem. We're glad to have you with us. So we're happy that you're here.
In relation to the documents, I just want to just get to the aspects. I do apologize.
So perhaps as you are there, let me just quickly reintroduce you, if you don't mind, Ruan, as you hopefully sort out your, excuse me, your gremlins. So Ruan is an attorney with a decade of litigation experience. He's a compliance officer for Bravo Scan. Bravo Scan have been instrumental in clarifying some of the legal compliance in South Africa and inspection processes. And they operate in multiple different departments, but the key focus on compliance, business management, they've navigated regulatory frameworks and have ensured accountability in high stakes environments. We're very grateful at SAPVIA that we've engaged with Bravo Scan in our last webinar, and we've put together a nice article creating some clarification on NRS and 09 and the NRCS. And currently he's also actually pursuing his qualification as a single phase tester and a SANS compliance officer. And his long-term vision is to blend legal expertise with marketing and compliance innovation. And it's this kind of session that's really invaluable for our industry. So, Ron, we are keen to hear from you, and yeah,
thank you very much.
Have you answer our questions, so go for it.
Can you see my screen?
Yes, 100%. Thank you.
Right. So just in the South African context, there's a lot of difference. I want to say there's a lot of standards in particular into relation to the electrical installations, and technically it's not supposed to be a unique field. The regulatory framework that we have been provided with as nearly 20 years old. And obviously that relates, or that obviously translates now into a little bit of a problem with the new modern era with the technologies that came in. Although solar is not something new, the fact that, however, in the last 5 years, there's a booming that your solar installation is into your house ultimately. And this is the problem that we face, that where your SANS regulations were on the consumer or the end user side, and your NRS installations is on the supplier side. And I'm basically want to show you the green aspect is usually what your COCs used to cover, and now with your NRS specifications, this is the supplier side on that side that comes in. And now there's a little bit of a contradictory. Sometimes these standards we find are in conflict, and now the electrical contractors are struggling to know what to do, how to do it, and how to do it safely, ultimately at the end of the day. All right. So here's just a breakdown of the applicable legislation in terms of what is on the user side, how that falls, and then on your utility side, what legislation is applicable on them. The issue normally is that when it comes to the user side, all of the standards are applicable on the user. And ultimately, but the problem is if there's a conflict, how do we deal with that conflict? And this is now where the hierarchy of the occupational health and safety comes in, where your SANS 10142 Part 1 code takes a little bit more precedence when it relates to a user. But in terms of the electricity and the definitions of the Act, all of the other applicable standards do become applicable. You'll see. Okay, before we start, I just want to say there is a lot of acts that you actually have to comply with when it comes to standards and compulsory specifications. What makes the South African aspect unique is the fact that it's one of the few industries that actually has I will say a declared code or a publicized code, being the SANS 10142 Part 1, and it's compulsory to comply with this code. Failing to comply with this code results into a criminal act or can translate into criminal sanctions, where other industries you don't have the strict compliance aspect. You have obviously the specifications that you need to comply with, and there's good engineering practices in terms of that. But the mere failure to comply to a standard or code doesn't necessarily translate into criminal sanction. All right. We also have got the Standards Act in South African, a law that makes the fact that once a standard has been publicized by the SABS or the NRCS, it's compulsory to comply to such a standard when it comes to the product aspect thereof. All right. And just some small facts. There are around about 5,000 standards, but only 53 of those standards are mandatory. All right. What also we have to take into consideration as electrical contractor side, on the user side, the Consumer Protection Act mirrors the Occupational Health and Safety Act. So if an electrical contractor doesn't comply with the standard, it's not just that they can get in trouble with the Department of Labor. There is also business and economical sanctions that are applicable. I want to say the last week or 2 weeks ago, there was a reach out by the Consumer Goods and Services Ombudsman and the National Consumer Commission, where they signed a memorandum of incorporation, where they are strengthening their ties when it comes to compliance or safety compliance of equipment and products, and that will definitely translate into actionable conduct from the consumer protection side, especially to electricians and installing solar installations. When we're kicking off the Occupational Health and Safety Act, and this is a complex aspect that we have to take into consideration, is that the definition of standard is very, very wide. It makes provision of the definition in the Standards Act. This is where your NRS becomes applicable, and then it also refers to any and all other institutions or organizations inside or outside the Republic, which generally, or with respect to any particle or matter, declare a standard. So in terms of the Occupational Health and Safety Act, that standard becomes a very important consideration when doing a work. And this is where your NRS will necessarily fall in. Because the NRS, they are, we'll get to the clarification and the legal aspects, how we understand. And I do apologize if I repeat the previous speaker's slides. But what we actually want to focus on is the conflict between the NRS specification and the SANS specification. And this is what the trouble is for approved inspection authorities as well as the electrical contractors. How do you deal with this conflict? How do we resolve this? Right. So Section 22 of the Occupational Health and Safety Act makes it a compulsory. This is what basically is the duty of care of the electrical contractor, to make sure that the installation and the product that he supplies complies with the relevant health and safety. I'm just going to rush through because I see that we're short on time, but I'll definitely make these slides again available to you guys via Subvia in order to if there's any further questions or follow-up. So just going to rush through in terms of that. But Section 10 is actually I want to say this is the whip, because any person who erects or installs any article, use, or work, or in any premises shall ensure, as far as reasonably practicable, that nothing about the manner in which is erected or installed makes it unsafe or creates a risk to health and safety when properly used. And in the evaluation of if you gave effect to this obligation in the Occupational Health and Safety Act, this is where your standards will then come in, where you're referencing the SANS 10141 Part 2, as well as the NRS codes and specifications. How far did you comply with these standards? All right. Then obviously there's a general duty on I want to say for everyone. This is not just limited to the electrical contractors, but especially with the users. Section 9 of the Occupational Health and Safety Act imposes a great obligation on them to make sure that that they don't expose any person to hazards or to their health and safety. And so there's a risk on your client also to make sure that the necessary risks are addressed. And if we can make it into an example, what I'm trying to say is that electrical contractors should be aware that the user, the end user, also has got the obligation in the Occupational Health and Safety Act that installation, the solar installation, doesn't pose a harm to a friend that might come visit or to other family members that utilizes that installation. So it's I want to say from the cradle to the grave. That's what I usually call it. From the cradle to the grave of liability, from the end user right up through to the supplier, ultimately is accountable in terms of the Occupational Health and Safety Act. All right. The Occupational Health and Safety Act, and this is where the conflict comes in between the NRS specifications as well as the standard, is because of this term reasonably practicable. All right. And this is the method or the methodology that the electrical contractor should utilize in order to evaluate the risk. He should first look at the severity of the scope of the hazard concerned. The problem with electricians or with the electrical industry, the risk that we are trying to navigate or to diminish is electrocution or fire. So that is one of the biggest risks that you need to negate. Other occupational industries will look at other risks, like let's say there's a pinch point or something sharp, and they can just put a cover on it. But when you're dealing with electricity, one of the biggest risks is obviously it's most severe. It's death that you're trying to. So the severity of the scope is usually in the highest or in the major or in the critical aspects that you need to deal with, right? Then it goes about the state of knowledge reasonably available concerning that hazard or risk. And that is where your standards, and this is where the aspects, it's all of the standards become relevant. And that if you refer back to the standard, the definition of the standard in the Occupational Health and Safety Act, it takes into account all of the standards in terms of this. The standards made by the NRS, the standards made by the by SANAS, as well as the ISO and the international bodies, all of that becomes a requirement in order to take into consider. And then obviously, and any means of removing or mitigating that hazard or risk. So it is an evaluation that you have to do. As well, then the availability and the suitability of the means to remove or mitigate that risk. Sometimes, and this is the problem that you have to take into consideration, it might create a product more expensive or the installation method a little bit more expensive, but is it available and is it suitable ultimately in order to remove the act? And then it makes specific reference to the fact that cost of removing or mitigating that risk or hazard in relation to the benefits deriving therefrom. So when you're evaluating solutions, you can't say, oh yeah, but this is I want to say the most expensive option, or it was expensively prohibitive. That is not the correct evaluation. The evaluation should be what is the risk that you're trying to mediate. So when you're trying to mediate or alleviate death or electrical fire, in most instances, the cost doesn't become a factor, or the relevance of the cost becomes a very diminishing factor ultimately at the end of the day. All right. And then ultimately, Section 47, very rarely do you find that's in legislation, but when it comes to the regulation of the electrical installation in the industry, the Occupational Health and Safety Act also binds its own regulator, being municipalities and the state, to the compliance thereof. All right. And then you can't, this is also something funny ultimately that we find, is that you can't contract out of these obligations. It's a mandatory compliance aspect that you have to comply with the Occupational Health and Safety Act. All right. And this is now back to the standards, the issue that we find with the NRS and the NRCS. We find in terms of electrical installation regulation 5, obviously you start off the fact that you have to comply with the regulations. This is the SANS 10142 Part 1 regulations that were proclamated under Section 44 of the Act. That is your first point of control, right? Then secondly, it's the product specifications, the NRS, that is your second point of call. And then ultimately, thirdly, you have to comply with the bylaws of the regulations of the supplier concerned. And this is now point 3. All right, so you've got this inherent hierarchy, the SANS 142 Part 1, your NRS specifications of your compliance, and then your municipal standards, and this is where the NRS, the role that they fill in there. But always, and sometimes, and in most instances, the NRS specifications are sometimes in conflict with the SANS standard. So we've got a little bit of an issue there. But we'll later on we'll see how we can address it from a regulatory perspective. All right. For people that don't know what is the NRCS, this is obviously a department within the Department of Trade of Industry, and they set specifications for products that need to comply with, that are manufactured on outside of the country and that are imported into South Africa. And especially for the electrical industry, the NRCS, it's a very vital component. We are struggling now with the matter where the NRS specifications in relations to cable become very critical in order to resolve the disputes. And we found out that the cables, although the manufacturer claims that they comply with ISO and IEC specifications, which accreditation is accepted, in the event that it's correctly done, we find that those cables don't actually have the necessary accreditation, and therefore are in contradiction and in violation of the NRSCS Act. And this is the problem that we have now, and this results into a multi-million rand lawsuit, especially with solar plants and stuff like that. So I just want to urge electrical contractors as well as everybody on the meeting to make sure that the cables that you utilize actually meet the NRCS specifications, because it's a hidden devil that usually comes out the moment that you just think that you handed over the plant. So it becomes an issue. All right, but the NRCS is a statutory regulatory body and compliance body, and compulsory obligations are set out in the acts and regulations, and we have to comply with these specifications. All right. Now, the NRCS, obviously, they are the National Rationalized Specification Association, and they regulate the suppliers. I'm not going to deal too much with what they are, what they do, and their functions are. I believe the previous inspection of the previous speaker did that for us comprehensively. But where our problem comes in is the fact that NERSA adopts the NRS specifications and it becomes obligatory to comply with. However, that it is not translated ultimately into the bylaws of the regulator. I just want to cut. Sorry. Here there's some municipalities that obviously adopt the NRS specifications, but not all of the NRS specifications are adopted, and this results into a conflict between the SANS standards and obviously our role as the approved inspection authority, trying to regulate and police the industry, which one you have to be compliant with, all of that. The Tshwane municipality actually, however, expanded the definition of specifications that needs to be complied with, but it's not. This is one of the first municipalities that I saw took this proactive approach. We find that there's a lot of municipalities that don't have this aspect in their legislation, so the governing of these aspects become then very troublesome. All right. Just want to come in perspective here. The mere fact that you are complying with the municipalities, obviously the municipalities as a supplier, they've got very stringent liability on them. If in terms of Section 26 of the Electricity Regulation Act, they are automatically liable if somebody is electrocuted on the infrastructure. So in terms of this, they try to minimize their accountability. So the mere fact that they are adopting or creating these specifications doesn't necessarily alleviate the user from this liability. And this also creates a conflict because the user is trying to set off its accountability and liability by complying with the SANS 10142 Part 1 codes. However, those might be in conflict with the NRS specifications, and the municipality ultimately can't provide adequate aspects or determination, because even if they rule on the matter, the user, in terms of legislation, remains accountable and liable. So it's this: how do you actually effectively deal with this over-regulated aspect in terms of that, right? This is just to say the promotion of the Administrative and Justice Act. On the previous occasion, we indicated that when you are compiling a standard or a code, it has, and especially when you want to incorporate that and make it enforceable, it is such an action, it constitutes as an administrative act, and therefore it must comply with the Promotion of Administrative Justice Act, which means there is a procedurally fair process that needs to be taken, and that process is not always upheld by the industry regulatory bodies and standard setting institutions, because they make the regulations and they don't properly consult as to what the effect and the consequences are. And this inadvertently creates to a conflict and a lot of aspects a little bit later on that we're going to discuss in terms of how do you deal in resolving this conflict, because it's a public-sized standard now, but it creates a liability or a technical issue later on down the stream. All right. Because there is, we as BravoScan advocate for the fact that there needs to be greater interaction between the SANAS industry setting bodies, the NRCS, as well as the NRS, and greater collaboration needs to go so that we can ensure that our bodies create the necessary framework of regulatory control that is needed, but that we can minimize conflicts and undue issues in terms of that. So we always ask, is a standard for success, or is it a standard for disaster? All right. So for success, we have to take into consideration the hierarchy that comes with standards. In terms of, this is normally our inspection methodology and framework. Internationally, we've got the international setting bodies, and then obviously your regional, national, industry, and very importantly, your company specifications that also come in. And that is more your manufacturer or your aspects in terms of that, right? This is one of these cases where it was a matter that was in the Supreme Court of Appeal, just to show what can happen. And when we use the term here for suppliers, it is for your municipalities, the disaster and the critical consequences that can flow from this. This was a very interesting matter that dealt with the erection and the creation of pylons, and the court obviously started with the Electricity Act, all right, and they delved, and this is a very interesting matter in terms of it, but they delved into the ADC or the standard from that Eskom applied in the creation of these pylons, all right, and the standard and design, and they looked specifically at the NRS codes that came into, and the courts identified a conflict between the various regions of the NRS code, because the municipalities on the one end in Cape Town designed the pylons a little bit differently as they designed the pylons here in Gauteng. And because of that, they indicated that there was a risk or an element that could, and if you, I highlighted all of the text of the court case just to make it a little bit more easy readable, but it's an interesting read. But the court ultimately came down to the fact that it said that this is the test that you need to consider. The degree or the extent of the risk created by the actor's conduct, the gravity of the possible consequences if the risk of harm materializes, and the utility of the actor's conduct, and the burden of eliminating that risk. And the court, and it's very important why the court, I would say, set down this test, because they went in further and they evaluated the approach in terms of how we deal with risk mitigation, problem solving, and obviously the application of the standards. And the court said the fact that it is identified in the standard creates that obligation on the fact that it amounts to a risk, and therefore it needs to be properly dealt with. And because you are aware in terms of, and that echoes the reasonable practicable aspect in the Occupational Health and Safety Act. And it's very important to stipulate in this particular instance, all right, the court only considered the Electricity Regulation Act, all right, and the Occupational Health and Safety Act didn't come into play. But because of the common law being adopted and the way that the actor, or well, the way that the Occupational Health and Safety Act mimics a liability in the common law, and the way that we assign or determine delicts and damages, the mirroring is so close that this actually is a very prominent case that to show you how the court will approach if there's a dispute between the act and the regulations, and then ultimately the conduct of the supplier and or the electrical contractor at the end. All right. The court further said that when you do not comply to the standard, whether it was possible to do so by reason of faulty design or improper installation need not be decided. The point is that although formidable in appearance, the device in reality did not constitute an effective barrier. So the mere fact that we stipulate something in a standard or omit it from a standard, ultimately at the end of the day, you have to take into this practical approach. How is the standard applied? What will be the outcomes and the effects of the standard? Because that is ultimately what we want to negate the user from. That is ultimately how we want to protect electrical contractors from. Even though we put this in a standard, what is the practical outcome that we will enable our customers and clients to achieve? All right. And in this particular instance, obviously the supplier was found negligent, and the negligence was found and established on their own evidence in terms of the NRS specifications and the codes and the standards. So, and this is where the standard was utilized against the supplier ultimately. All right. But it's not just suppliers and electrical contractors that are at risk. There's also accountability on the user. In this particular instance, we made reference to Section 9 and then obviously Section 37. The user has got this great accountability that he also needs to make sure that is enforced. And this is why this standard problem is not just a problem that remains between the industry bodies and the electrical contractor. This actually translates into a very real legal and financial risk to the end consumer ultimately at the end of the day. All right. In this particular court, the court stipulated that Section 9 of the Occupational Health not only imposes a duty of care on the employer, but also provides for a standard of care. So, and that standard of care, that is where the regulations and the standards and our approaches become very prominent. Liability arises from the foreseeable risk of inherent in the employer's hazardous activity and operations. All right, and it further extrapolated with the increase of the risk requires an increase of a duty of the care and the obligations to remove that risk. So again, we need to make sure that our standards and that what we apply need to meet this threshold to ensure that it actually becomes into a workable document or a workable approach or regulatory framework if we're going to use different acts and standards, but ultimately protect the user and the electrical contractors at the end of the day. All right. And this is what we approach. This is what we're trying to do from BravoScan, is we want to advocate for an industry-wide holistic approach. And that is why we appreciate Sapvia in order for these sessions that we can participate on, showing what we find out on the field, how are we going to alleviate these problems, facilitate the engagement of the various stakeholders and the industry-wide, so that we can come to a point where we say, okay, this is how we're going to resolve the problem. And obviously, we want to say that we're all in the same boat when it comes to the court cases and I would say, and the liability. There's no distinction between the user, the electrical contractor, or the supplier, in this case, the municipalities. We're all in the same boat as we face the same legal duty of care. All right. Sorry for rushing through my slides. Like I said, my invitation said 1. So I hope if there's any questions, please let me know.
Yeah, carry on, Rod. We're doing well. Thank you.
All right, now I'm done. Sorry about that.
Wonderful. Thank you so much. That was very comprehensive. And just to remind everybody that we are recording the sessions. You know, there seemed to be some confusion about different times starting. I know some of you are joining us now at 11. And so apologies if there was a confusion about the time there. Mr. Mkhize, I wonder if you, having looked at BravoScan's presentation, there had any comments or confirmations or affirmations. I'd love to get your thoughts from nurses' perspective as to what was discussed here. Mr. Mkhize, if you could make some comments.
Yeah, no, thanks, Chair. But, my view, based on the presentation, is just that I think there has been a more in-depth sort of dissection of the different standards that are applicable, and I think that has then probably enhanced and helped a lot in order for us to, just distinguish between the various pieces of legislation that are applicable in this space. And so I think that is useful because, with all these different pieces of standards and guides, one can easily get confused as to, what exactly one needs to comply with. But I think I do agree with Ruan that there needs to be a sort of like a consolidated document that can guide installers as well as users, just in terms of, what needs to be complied with. But I think what is also coming out of this conversation is the fact that one needs to really look at two things. The first being the products, and then the second being the compliance of the installation. So the products need to be compliant with the NRCS. And I saw a question there on the chat which says that who then has to test these products, to make sure that they are indeed compliant. And I don't know, but I think the SABS, the SABS, is the authority that has to test products and ensure that they are compliant with standards. But I think at the end of the day, it will be very useful to have a list of compliant products that are applicable in this industry, so that users and installers can be able to go on the Sapvia website and then be able to verify which products are indeed compliant. And then, of course, the second leg is the installations. And I think it has come out quite clearly that the SANS 097 is the standard that one has to adhere to ensure the compliance of grid-connected, particularly installations. And then, of course, the SANS 10142, which outlines, the wiring of premises and so on, to ensure that it is compliant with all safety requirements. So I think that's what's emerging here, Chair. Over
you.
to you. Thanks.
Thank you. Ron, if I can come back to you, you've put a nice screen on a shot on our screen there. You've mentioned SANAS, Mr. Mkhize mentioned SAVS. Yeah, there's many, there's NRCS, there's NRS, there's a lot here. Can you maybe, you mentioned there's SANAS inspection body. What is their role in South Africa, in the South African Bureau of Standards, in those roles? Because it clearly seems like there's a need for some kind of coming together to clarify all of this. And I'm aware of many bodies. I mean, we at SAPFI are trying to do that in some regards from a manufacturing point of view, because we want to assist local manufacturers to make sure that there's compliance. And I'm aware that that's a very difficult route in South Africa. So perhaps for those who are joining us, can you speak a little bit about SANAS, SABS? Is there a need for us coming together? Or is it a specific, in your mind, is it clear cut that no, SANAS is the one that should be leading this in clarity and bringing in the bodies together?
No, I want to say it is actually, for me, the regulatory framework is already in place. Right. If you understand the role of SABS and SANAS, round about in 1998, just to show you how we got to the point that we are here, we had a very prominent SABS aspect, or of a very strong department of SABS. They created the specifications and the product specifications, and they were also involved in the making of the marks and testing these equipment. So they had a lot of these testing facilities ultimately, but then the Competition Commission said, well, with the enactment of the Competition Act, you can't be judge and jury and executioner ultimately, because you can't set the standard and then test or have a business aspect of testing the equipment against the standards that you set. And that's created a lot of aspects of the, I would say, conflict with SABS. But it was a very strong regulatory model because the functions of the one supported the other, and there was a whole financial aspect. But with the breaking up, you get the SANS. This is the standard setting body, SANAS. They set the specifications, right? So they facilitate the process with product manufacturers, and they create these standards, right? And SABS, although in existence still today, but they focus on the product testing in terms of that. But when these aspects were, well, when SABS was broken up, there was the ability in terms of the South African Standards National Laboratory, that's currently the SANAS Act, for private organizations to also enter into the sphere in order to create these test laboratories, where your products are tested and all of that. And this now is where the issue comes in. You've got SABS testing, and with the Department of Trade of Industry, and you have to understand the Department of Trade of Industry and the NRCS, they work in relation with the SABS and the standard setting bodies, but we've got also international obligations with bilateral agreements and taking in products from other countries and all of that. And that is where the NRCS is involved, facilitating these negotiations, because it can become very, very complex with regards to what products we actually enter into our country. And in order to facilitate trade, the NRCS facilitates this whole process that you can have a product specifically tested in the European Union or designed specifically for that market, and then utilize that product here, and we recognize that safety aspect. But we also have to have that delicate chance to say, no, you can't bring this product into South Africa, because in the South African market, it will be unsafe or dangerous in terms of that. In order for that product to be sold here, you have to meet the following specifications and provide us with proof that you tested in terms of that. So in the South African framework, there is scope and space for laboratories and test houses in order to do that. But because of the impartiality and the conflict, very rarely do you is a test house profitable, unless it very it must specialize into a very unique field because the equipment in order to test these aspects are very expensive and prohibitive. And then obviously that market is very, very narrow for that specialized product. And obviously there must be a distinction between the manufacturer and obviously the test house. So economics ultimately is bringing us to the point where this I want to say this aspect is that we have got this conflict. We think SABS is not working, but there's not just SABS. There's other test houses in South Africa called Safe House, and I think there's a number of testing laboratories currently out there, but they are so specialized in terms of that, and the funding is very much limited. And obviously you have to test the product under specific conditions, and then you issue a certificate for I think 2 to 5 years. So you can see why on economically it becomes unsustainable to operate these test houses. So the regulatory framework is there. It becomes with the usability and the enforceability ultimately that becomes an issue. And then obviously the conflict with grey market products or untested products coming into the country. Your consumers either and this is how I want to say the consumer as a whole, your industry wide is uneducated. You'll accept cables for big or large installations, thinking that you're buying this from a reputable supplier, but then the necessary accreditations and checks haven't been done, and you find it out a little bit later. And then obviously your suppliers, your small, medium, and house suppliers, they usually just take a product from the shelf, and very rarely go into the compliance aspects of what is actually needed from this product in order to make sure that it's safe. And then only when there's an issue, it realizes, okay, these plugs cannot be utilized. Just case in point, we did an inspection in a house in Cape Town, one of those fancy houses. 250 plugs had to be replaced because the neutral and the live wires from the factory was switched over, which rendered the plug unsafe ultimately, and all of those plugs had to be placed. But it came with the necessary certificates from the supplier, but obviously the factory didn't have the necessary tests. So you've got that aspect also coming into play. So it's a very difficult environment. So where it comes back into is the fact that we need to advocate for consumer education, and then obviously for suppliers to make sure that they are getting, and they only support product compliant aspects or the NRCS or product specifics that they comply with, that they purchase. They don't purchase grey products in order to make sure that we can work out this economic issue that is faced from the regulatory side.
Yeah, thank you, Ron. I think that's a very, very important point. From a manufacturing working group for SAPIA, it is by far our biggest conversation that we've had over the last 2 years, is that as local manufacturers, there is very little support or assistance when it comes to local testing and certification. So there's a huge gray area between NRS and NRCS, which is why we've put these webinars together. So I think that's a vital aspect. I think on the other flip side of that is that we have massive amounts of products being imported and brought into the country that are not being verified. A simple sticker on it and it's just accepted without perhaps a local verification body. And unfortunately, in the domestic market, it's too late for that. We know from a CNI side and from our EPCs and the larger farms, wind farms and solar farms, we know that there's very restricted regulations there. But from a domestic and perhaps light commercial point of view, there's been very little verification of that. And so we've had massive dumping of products into our country without that verification. I think we sit with a major problem going forward over the next 10 to 15 years. We started to see the first effects of that, I think, of the 2017 load shedding, with everybody having perhaps purchased a cheap inverter. Now that inverter no longer works, can't be repaired. And there's a massive electronic waste problem that we are dealing with, and it's constantly coming up in our discussions from a SAPIA and a manufacturing working point of view. I'm not sure, Mr. Mkhize, whether we should be speaking maybe into this, that we should be, from a regulatory point of view, saying that we need to tighten up with what's being imported into the country, because it's been a grey area, as Ruan has mentioned. Is there some efforts from NRCS side or focus that this something needs to change in this regard?
Yeah, thanks for the question. I think it's a very, I think it's one of the gray areas that have actually fallen through the cracks, to be honest, Chair, because, you know, if you look at the role of the DTCI or the DTIC, Department of Trade and Industry, you know, these are the areas that they really should be looking at, you know, in terms of deciding what products should be and should not be imported into the country. And for those that are imported, you know, the various tests, applicable tests that should be done. So, but I think on our side, we have that advocacy role that when we do identify such gaps, we can take it up with the relevant departments. So this is something that we can highlight, you know, through the DTIC as a gap, you know, as something that needs to be looked at, because indeed, you know, the SABS was supposed to be a sort of a government-owned testing facility that, you know, if it needs to be capacitated to be able to do these tests, then that should be done. That should be done. You know, it should be capacitated to ensure that it can do the relevant tests. I mean, and that is to protect our local industry. And I think this is something that really should be highlighted. And if it is seen as something important enough for the country, then funds should then be made available so that the SABs can then be able to, you know, to do the tests accordingly.
Yeah. Mr. Mkhize, then guide us from a manufacturing point of view, and for those on board here, who should we be engaging with? We've spoken about a number of matters here, this being a grey area that has certainly hurt the manufacturing industry in South Africa because there's been very little being done about it. Maybe it's too late, but who is the right bodies to engage with on this, that we can have this conversation and see what needs to be done?
Well, I think you are engaging NRCS currently, and that is a good start because, as I said, we have got this advocacy role that we can engage government when we see a gap in the industry, or rather, we can engage the relevant, you know, department to ensure that the gap is closed. But then, of course, you know, you can also engage, you know, with DTIC. Directly to just advocate and to make them aware of the issues and the gaps. And then, of course, they are always looking for incentives. You know, what jobs can be created, what jobs are at stake if this is not done. So I think it's important to put a value proposition on the table to say, look, we need to do this because this value can be brought, or this value is at stake. So I think it's important to develop those, you know, those value propositions and to put them on the table for a discussion with the relevant departments in government.
Excellent. That's very good. Thank you.
Gareth?
What? Yes, please.
If I can add to that point.
Please.
I think and I think this is the purpose that we ultimately want, is for the departments to start discussing with one another. We need to advocate greater collaboration between the SANAS committees, as well as the NRS committees and NERSA, as well as then the NRCS, and to permit these bodies to sit in or either facilitate a collaboration aspect thereof. And I would say, lean or lend. I do, my Afrikaans is shining through, but I want to lend on the banking industry, how they approached cybersecurity, because they've got confidential information and conflicts of interest. But one thing that they came together and said in relation to cybersecurity, this is the approach, and they facilitated a body or created a body to exchange information between the relevant industries and conflict and on. Everybody sat on this body, but it translates into actual and progress communication that translates into actual aspects at the ground floor that can be implemented, and it's to the members' benefit ultimately. So perhaps we should consider approaching NERSA, especially as the overarching electrical regulator, to create such an interested body in terms of that, so that information between the various standard setting organizations and requirements can be discussed and circumvented and regulated and adapted and changed, and that will alleviate, I think, that will be the first port in order to alleviate and to get this ball on, the process rolling.
Thank you. And I'm going to ask our two speakers just for some final comments, because of course we are wanting to talk about some practical guidelines for industry as well, for our manufacturers and our installers. I want to make one comment though before we do. I'm going to ask Mr. Mkhize and our gentleman from Brovoscan just to make a comment in terms of practical advice for our installers, our manufacturers. This is a manufacturing focus group, of course, as well, regarding process. I mean, I've just come off a session this morning with Manufacturing Circle. They sort of mandated to fulfill SAREN, South African Renewable Energy Master Plan. Last week, I was at the South African Energy Efficiency Conference speaking there with Sanedi. There's a lot of pockets speaking very similar to what both our guests are speaking on today. And it feels like a consolidated effort. And maybe, Mr. Mkhize, it's NERSA's role to really take the lead in that, as we are discussing that today. But it does seem that there's many pockets all trying from different aspects, from a manufacturing point of view, from a policy point of view, to all get on the same page. SAREN perhaps was intended to do that, and I see them really pushing hard. There's a lot of money and effort being put into trying to do that. But we certainly do need something to happen urgently. And I bring it back to our manufacturers, because our manufacturers are slowly closing up shop. They're slowly shutting their doors. I see it in the industry that I'm in, that there's not many left, many on short time. We're in a crisis when it comes to manufacturing, and many of the manufacturers will point and say it's that we haven't put the policies in place, that we haven't made these decisions quick enough. We're playing catch up all the time. And today's webinar is about the practical advice that we would give to manufacturers and installers who are struggling to navigate this compliance, this gray area, this need for us to turn this job collapse that's happening, the skills brain drain that's happening, and turn things around. So I'm very keen to hear from perhaps a practical, I think we've had a lot of that already, but just as a closing comment from our two speakers. I wonder if I could ask Mr. Mkhize just to make comment first, and then I'll ask Ruan Kutsia from Brovoscan for a final comment as we close. Mr. Mkhize?
Yeah, Gareth, I think probably Ruan is better placed to really give us that kind of advice, But I think, Ruan, this is a crisis in the country. We also have smelters and other heavy industries that are really in trouble and shutting down and so on. And I think it all goes back to the Department of Trade and Industry, and its role or active role in ensuring that it puts an industrial policy for South Africa that will ensure growth and ensure that especially the job creating sectors are protected. But of course, that has not been coming forth quite strongly. But I think, Gareth, there needs to be a proposal on the table in terms of the things we've discussed today, as I said earlier. And that then needs to be then presented to the relevant bodies, because there's only so much that the regulator can do. I mean, ours is more limited to electricity, related matters, but not so much industry-wide. We are entrusted with the role of ensuring the development of the electricity supply industry, to be specific. And so I don't know how much aware you are about how we've also been pulled into trying to save ArcelorMittal recently and so on by approving a preferential tariff. And those are all attempts to try and save an entire industry just with electricity tariffs. But I really think there's more to it than just electricity. There needs to be an industry-wide, and this needs to be looked at also industry by industry in terms of what policies need to be in place to make sure that these industries are protected and they are sustainable. So I think looking at the PV industry, we need to put together a proposal in terms of policy proposal, that this is what is required, and then that needs to be then put before the relevant authorities. But just as a practical way forward in the meantime, Gareth, I have shared the notes that I had prepared for this session. And I think that does provide a bit of a guide with respect to what we've discussed. So I think that can be useful in the meantime, just to guide our installers and your your members of SAPVIA in the meantime. So with that, thank you very much, Chair. Over to you.
Thank you. Thank you, Mr. Nkisi. Really appreciate your time. Ruan Kutsia, Bravo Scan, your closing comments in light of everything we've said.
Yeah, so Gareth, the way that you said it, you can make a very sunny day very bleak. But with that, I think what we should realize that it's not on the regulator to provide us with the perfect economic conditions, or in terms or the perfect economic climate for that matter. Obviously, it will help, but with great challenges comes great opportunity as well. And for the industry, yes, we are facing a lot of headwinds, and it's not, some of it is not of our own making, with especially on the, if you take in the international aspects into consideration. But we definitely should shift our focus on, instead of the dragons that we are facing, to focus on our customers. And for the government and for the regulator, obviously it's the end user, and for us and the manufacturers is it's our customers in the economy. And to make sure that we meet their demands, that we go out and provide them with the best service and the best products that we can possibly could. Because even if we just sustain ourselves through these troubled day times and set ourselves up for when it goes better, to build a platform from which we can jump off of. But I think we should focus on ultimately the customer at the end of the day, and from the regulator side, that is also the whole economy on a sense. But I think there's so much hidden opportunity that we just have to sit back and relax and realize that we can't face this on our own. We need the regulator. We need our competition in some instances. We need our customers at the ultimate and the end of the day. And we also need other industries as well to look at what they are doing. And from all of this, we can draw lessons and to realize that we're all in this one boat. And you might be with an oar on one side, but you need to grab that oar, and you need to actually start rowing. So in order to make a difference.
Ruan, thank you so much for your wise words. Thank you, Mr. Nkisi, for your wise words. We're certainly not here to open up a can of worms, but we are here to really plea, I think, for those who are in influential positions to be aware of the massive challenge that manufacturing is facing in the country. Again, just as we close, I want to just apologize for those who perhaps had the times incorrect. There was some confusion about that. The webinar will be made available. And again, urging anyone who is in the manufacturing space to engage with us. We'd certainly welcome you joining our manufacturing working group. As you can hear from the discussions, this is really what we're trying to drive and create a platform for sharing these thoughts from a SAPVIA point of view. And I certainly think, Mr. Mkhize, we will speak with our management at SAPVIA as well. I'll give some report back to them regarding some of the comments and suggestions made. We would encourage you all just to stay in connection with SAPVIA. Our team will be sending you through all the information. Yeah, for wherever you are in the country, in the world, we really do appreciate your time. Please be safe. God bless you all. And thank you for joining us, everyone. Goodbye.
Thank you, Chair. Thank you, everyone. Goodbye.